Hello and welcome to this 7th video produced as part of the series of videos for the Reveal project. And in this video we're going to focus on intellectual property and libraries. Now just to remind you, the Reveal project stands for Reinforcing Ethics and Values for Effective Advocacy for Libraries, and it was funded by the CILIPS Research Fund to enhance collective advocacy across the profession through an accessible framework for library and information ethics and values, presented as a set of continuing professional development tools. And these videos form part of those tools. As I said, this is the 7th video in a series of 10, and it will focus on intellectual property and libraries. In terms of what we'll cover in the video, we'll discuss what and who intellectual property rights are for. We'll discuss some of the controversies around intellectual property rights, and we'll consider how intellectual property rights impact on libraries. Now, it's important to start this discussion and our reflections on it by recognising that intellectual property has actually been recognised as a human right. Article 27 of the Universal Declaration of Human Rights says that everyone has a right to protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. Now that's all well and good, but if we compare Article 27 with Article 19, which states, everyone has the right to freedom of opinion and expression, and this right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any medium and regardless of frontiers. Now, we've obviously already discussed freedom of expression in another video, and I encourage you to go and look at that video as well if you're interested. But hopefully what you can see here is a significant tension between these two rights. On the one hand, you have the right for people to protect their creations essentially, which usually relate to some type of information, be it a book or some kind of scientific discovery. On the other hand, you have the right to essentially seek out information and knowledge to make you more knowledgeable about society. So really, comparing these two human rights, this is really the nub of the dilemma in intellectual property and what we face in libraries. So we can reflect on these two rights and how they might clash. I think you're really on a good path to understanding intellectual property and the tensions that it presents. Now, the history of copyright in the UK began in 1709 with the Statute of Anne, and this is recognised as the first intellectual property law. And what this did essentially was seek to challenge the widespread copying of books by printers. Obviously, this was the era when technology was improving and printing presses were becoming much more economically viable. And without protection on existing materials, then essentially people could copy without any repercussions. So the Statute of Anne was an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of such copies during the times therein mentioned. And the statute gave a 21-year protection to existing books and 14 years for new books. And the punishment for anyone who breached the law was that copiers should forfeit 1 penny for every copied page they had sold or were in possession of. Now, the law in copyright has been updated many times for many reasons. So an important aspect of this was the Berne Convention for the Protection of Literary and Artistic Works, and this was adopted in 1886. And this led to reciprocal recognition of foreign works. So essentially, you could understand that your work would be protected in other countries as well as your own. The Berne Convention was revised in 1908, and this led to a new Copyright Act of 1911. And this made copyright active at the moment of creation, so there was no longer a need under the law to register with the Stationers' Company in London. The next act was the Copyright Act of 1956, and the most recent act is still the Copyright Designs and Patents Act of 1988. Although that act has been updated several times for different aspects of the law, like the explosion in digital materials, it is essentially still the main copyright law in the UK. So what is IP law there for? Well, as Frozio notes, the Statute of Anne set in place some fundamentals related to intellectual property law. Firstly, that rights to protection should be limited in terms of time. And secondly, that once protection has expired, that the public should be able to utilise the content freely, otherwise known as the concept of public domain. Now, both of these points are very important, and it is really crucial that we go back to the Statute of Anne and consider why the laws were introduced in the first place and what they sought to do. So I think Frozio is correct in his analysis. Firstly, copyright protection or intellectual property protection should have a time limit on it, so it's not for perpetuity. And although some organisations may lobby for the longest period of time possible, this recognition way back in 1709 was very important. You're not being given protection forever. You've been given protection for a set amount of time, however long that time is, and it obviously has increased over the years. But really, that fundamental point's important. And secondly, that once that protection has run out, once it's expired, that really the intellectual creation should be part of the public domain, which means that the wider public and society should be able to benefit from that without any repercussions on them from any rights holder. So both of these points are very important fundamental issues that we need to consider when it comes to intellectual property. And now, considering again what IP law is there for, well, relatively straightforward really. Firstly, to offer protection to the creator of a work for their creation. And this allows the creator of a work to challenge any misuse or abuse of their intellectual creation through the courts. Secondly, to encourage new work, to ensure that people were incentivised to create new works due to the protections the law provided, and conversely, not disincentivised because their work could be copied with no recourse. And lastly, to provide the creator with recompense for the work. And obviously this is linked to both of the above functions, that the creator can earn financial rewards for their intellectual creation. So 3 rather straightforward points here that IP law is there for. Really is to protect the creator, to make sure that you're encouraging people who are creative, who have something to offer society, to be able to get some money back, some recompense for their creations. The idea being that giving people that right to protect their materials means that society benefits because new ideas, new books, new technologies, new drugs, etc. are created. So really, fundamentally, that's what IP law is there for. Regardless of how you might see any abuses of it, ultimately, those 3 key points are what it's about. But that leads to discuss the issue of the excess of intellectual property rights. Benadio and O'Connell argue that excessive intellectual property rights can potentially be damaging. They say that they contribute to creating an environment where more and more people are led to hate IP law and view it as a protectionist regime, which discourages creativity and innovation and ends up safeguarding the owners of monopolistic rights, which restrict trade, competition, and people's freedoms. And I think it's fair to say this is a recent book, Benadio and O'Connell, but I think it's fair to say that that view is something that's quite common within society. The idea being that intellectual property rights, regardless of why they were introduced in the first place, actually restrict access to information because it gives far too much power to large media corporations who can use that power to restrict access in various ways, firstly by technologies, as we'll discuss later, but also by overpricing the materials to make it unaffordable, which again, we will discuss in the context of libraries later. So, a valid point, I think, that is worthy of consideration, and certainly one that is of major contemporary concern. But what do we mean when we talk about intellectual property rights then? They're usually categorised into moral rights and economic rights. So moral rights relate to the intellectual aspect of a creation and the right of the creator to challenge derogatory treatment and the like. On the other hand, economic rights relate to the financial aspects of the creation, and these are usually waived by a creator. For instance, if you're an author who signs a book contract, you normally waive the economic rights to the publisher, and essentially they will obviously pay you whatever you've agreed in the contract, but the economic rights become the publisher's rights to basically maintain and chase for you on your behalf. Now, it's important to note that moral rights are always retained by the creator, and these cannot be waived. So these relate, as I said, to the intellectual aspect of the creation. Now, I think it's fair to say that when most people think of intellectual property rights or copyright, they are normally thinking of economic rights, this issue that large corporations or publishers make money from books, media, etc. They very rarely consider the issue of moral rights, but I think it's important for a profession like librarianship to be aware that both of these rights have their place and both of them need to be considered and respected. So what are the tensions then? Well, as we stated earlier, tensions between protection of intellectual property and the right to access information are an ongoing issue. We saw within the Declaration of Human Rights really what are essentially opposing rights, or potentially opposing rights. Intellectual property law allows rights holders to protect their materials via law, and as such, libraries need to operate within this legal boundary, regardless of the moral or ethical issues involved, and how we as individuals, or even as a profession, might see the issues. We have to work within that framework. As we'll see later though, there are ways of campaigning and advocating for fairer systems, but ultimately we are still restricted by the law. Now, just utilising this figure that's taken from a book by Jonathan Milden called Patrons, Curators, Inventors and Thieves. And he highlights what he sees as a contested narrative of copyright, which really relates to, on one hand, the notion of openness, society that views information as a societal benefit, versus one that looks at essentially intellectual property as a protectionist element. So on one hand, you have what he calls the wiki discourse, and on the other hand, prevailing discourse. So I'm not going to go through each individual one. Obviously, if you want to kind of look at it in more detail, you can have a look at the slides. But on one side, in the wiki discourse, we have the view, for instance, that intellectual property law essentially is a state-bestowed privilege, contrasted with the entitlement that is a prevailing discourse that essentially intellectual property is a natural right of the author, both economic and moral, and that should be protected. So on one hand, you have a more free attitude towards intellectual property versus one that is actually very much focused on the rights of the individual and the company that actually owns the material. Obviously, they are clashing in terms of their concepts, but they are worth considering under each of the categories you can see. So as I say, please feel free to look through the slides and consider what you might think, how you fall down in terms of the debate. But I think it highlights quite neatly what the debate is at the moment in time. So we're looking at this idea between free access to information, making it as accessible as possible, versus on the other side, this idea that we have to protect intellectual property because it's a driving force of the economy and it's a right that needs to be protected. And, there are tensions that exist between the two of them that are worthy of consideration. And that brings us on to consider electronic materials and intellectual property. So one of the most challenging aspects of delivering modern library services is essentially the increasing costs of delivering digital materials. And it's still a relatively new thing. In the 1990s, when it began to happen, there really wasn't a major focus on electronic materials that we have now. In traditional libraries before the rise of technology, it was straightforward to procure stock, as the library would buy the appropriate number of books needed to serve the community. But the rise in electronic books has meant that the publishers have complete control of the materials and are able to charge significant sums to libraries for such provision. So consider, for instance, academic libraries who might have courses, first-year entry-level courses in large subjects like politics or psychology, where they may have 400, 500, even more students, all seeking to access the same materials. Now, how they coped with that in the older generation, when I was at university, for instance, was that you might have multiple copies of a set text, so an introductory book on psychology or sociology or the like. That would be made available in some kind of short loan format, multiple copies of the physical book, which obviously meant that you had to buy lots of copies to serve that community. In theory, electronic books allow you to make that more easy to access, but it comes with a premium cost. But in addition to cost, there are also fundamental differences in how libraries provide access to this information. So, as I said, in an analogue world, the library purchases a physical copy of a book or resource, and it's usable by one person at a time, so you would normally buy multiple copies if you want multiple people to use it. In the digital world, access to resources is usually provided by a vendor of digital materials to the library, and the users access the materials via this third-party vendor's website or, increasingly, app. So access in this context is usually based on a license provided by the third-party vendor, which may allow multiple users to access the resource at any one time, but also place restrictions, such as limits on the amount of the material that can be downloaded and or copied. Essentially, the app or the website of the third-party vendor controls the experience of the user. And importantly, the costs of electronic resources are often more expensive than single physical copies too, since the argument is that electronic resources are value added. For example, you would normally have 24/7 access, including usually access remotely from home or the workplace and the like, so you don't have to physically go to the library for the book. You can access it electronically anytime, day or night. But clearly such costs, in terms of licensing and infrastructure, can have a significant impact on libraries attempting to maximise access for users. And that's notwithstanding obviously the benefits. The benefits of accessing at your convenience are clear and they're there. But all of this, as I said earlier, comes with a premium. And essentially intellectual property law is the backbone of what gets charged. Now, one campaign that's been very effective so far is the eBook SOS campaign. And what they're trying to do in that campaign is raise the issue of the fees charged by some publishers for providing access to their electronic resources. This campaign was initiated by librarians in the United Kingdom, and it sought to make the politicians and the public aware of just how expensive providing such access has become for libraries, especially in the university sector, where the pressure of increasing student numbers and meeting their needs necessitates the usage of electronic resources much more than in some other sectors. It is fair to say, though, that electronic books and electronic resources and the costs for libraries are a universal problem, not just for higher education. But higher education, I think the focus is very clear there because of the numbers of people who need access to the materials in a very short space of time. They're only at college for a short period of time. They might have one class in a semester, for instance. Then obviously their need is very, very timely, and the libraries have to support that need. But it's really a problem that affects all sectors in varying ways. Now, what are the challenges? Well, the crisis in the funding of electronic resources highlights the clash between the library as a gatekeeper and the intellectual property rights of publishers. On one hand, publishers will argue that they're fairly seeking to maximise their income from their intellectual property, while librarians will argue that libraries are being priced out of providing access to users. The eBook SOS campaign, for instance, has a website, and on that website they have a spreadsheet where they show you an example or examples of different textbooks and what they're being charged for them. So one example I took from that spreadsheet, for instance, relates to an education textbook, which is priced at £480 for a single user licence for the electronic book. And that essentially means it's £480 for one user to access that book at any one time. Now contrast that with the book price on Amazon. So on Amazon, the same book is available for £28.99 in paperback format and £23.68 in Amazon's own electronic book format, Kindle. Now clearly there are differences. If you buy a Kindle copy, then the licence for that would mean that you would only be able to access that, or perhaps anyone else who would use your Kindle. And if it's a paperback book, again, only one person can access it at the same time. So there's clearly a premium for an electronic book that more than one person can access. But obviously, in this case, we have a single user license. So it's essentially the same as one physical copy of the book in the library that only one person can access at the same time. So essentially, you're paying over £450 for the convenience of the digital file, not for any further access to the book. So you can see why librarians and obviously people who fund libraries are very concerned with such pricing. It doesn't really pay close scrutiny when you see the differences. If it was multiple users for that price, then yes, but it's very hard to argue that one copy of a paperback book in a library would not be used many, many times before it became obviously so badly damaged that you would have to get rid of it. So £480 for one single user license for an ebook versus £28.99 for a paperback book is hard to justify. So this leads us on to consider the notion of new ways of working. There are perhaps also some more fundamental concerns here that we need to look at in terms of relationships between electronic vendors, libraries, and the communities that we serve. Gorman quotes librarian Adam Feldman, who, in reflecting on these transformations, stated that the complex webs of intellectual property law and vendor contracts guarantee that this E branch is a pale shadow of the spectrum of human publishing represented by a real-life library curated by librarians who know their communities. So while not perhaps specifically an intellectual property question, this whole notion of electronic vendors and how we interact with them and the types of services that we offer users as a result of those interactions is definitely something that we need to reflect on more. Now, notwithstanding the real issues related to the funding of electronic resources, this fundamental shift in relationships between services and users does need to be much more fully explored, and issues such as ownership, access, and inclusion all reinforce the competing rights elements that interact. For instance, when it comes to things like electronic journals and electronic books, previously you would buy a copy of the book for a library or the journal for the library, and you would own that. Increasingly, what we do with electronic materials is essentially we rent them. So we rent access to a system, which, if we can no longer pay the fee, might often mean that we're cut off from that if the costs become too prohibitive. Whereas when you bought the physical book or the physical journal, it was yours forever. So that's not a minor thing. That's a crucial consideration we need to think of when it comes to libraries and the changes in relationships and power dynamics. Now, perhaps what we have here are unresolvable clashes of rights at play. The right on one hand to maximise benefits from intellectual property versus the right to access information and the benefits it entail from wider society and individuals having access to information. One way we can think of this is essentially back to basics, to steal that phrase. The concept of intellectual property is really not a bad one. Societies benefit from the creation of new knowledge, whether literature or inventions like new drugs or technologies. At debate, really, is not intellectual property law on its face. At debate are what are the limits that are fair and beneficial, and who we deem to be the beneficiaries when and for how long. So, for instance, how long should copyright law exist? What happens when that copyright expires? And what powers should rights holders have over their intellectual property? And obviously things like libraries. What privileges should libraries gain when it comes to intellectual property when they're really out to serve the best interests of society? As Frozio says, copyright law was crafted out of broad civic purposes as well as strong anti-monopolistic sentiments. So it's important to reflect that whatever copyright law has become, the initial designers of the Statute of Anne did not put a perpetual right to benefit from intellectual property. It was rather limited. And the fact it's grown over the years from 21 years to 70 years is absolutely problematic. And we need some debates about whether that's excessive or whether it should be more limited. But let's not consider intellectual property law in itself as a bad thing. So in summary, we've considered the purpose of intellectual property law and the tensions inherent in supporting the right versus other rights like access to information. We've considered the discourse around intellectual property rights and the clashes that exist. And we've also considered contemporary advocacy for fair pricing of digital materials for libraries. In our next video, we're going to focus on some of the other contemporary ethical concerns in library provision. So we'll consider things like sustainability, equality and diversity, and we'll also consider at length the issue of neutrality and how that impacts on libraries.